In this video I want to talk to you about enduring powers of attorney. The law has changed significantly in the last few years surrounding enduring powers of attorney. There's a report there in the Irish Times today, and today is the 4th or 5th of June, 4th of June 2024. There is a report in the Irish Times today about a legal care backlog amid a dispute between the Law Society and the Decision Support Service. And the row centres on, we're told, enduring powers of attorney, with users saying that they have problems completing the necessary documents for future care arrangements. This row has broken out and it has threatened to undermine the structures put in place to protect vulnerable and older people, and in particular to allow for the setting up of an enduring power of attorney. The Decision Support Service began operations last year in 2023. It was given responsibility in law for the drawing up of enduring powers of attorney, advanced healthcare directives and various decision support arrangements, including for people who would formerly have been made wards of court. The purpose of this change, this setup, this legislation, was to make it easier for people. So people using the system must first register with the service and have their identity verified. They can then use one or more of the services it offers and supervises. This row centres, however, and all I want to speak about, is enduring powers of attorney. The DSS, that's the Decision Support Service, says is an area which has been the busiest since it started operations. Enduring powers of attorney, remember, allow people to set down in a legally enforceable document who should make decisions on their behalf in areas such as personal care, their living arrangements and their finances, if they are no longer able to do so in the future themselves. In other words, they lose capacity to make decisions for themselves. The DSS, that's the Decision Support Service, says by the end of last month, that's May 2024, more than 3,000 EPA applications had at least got to the point where the necessary medical and legal certification is required to confirm that they understand the process, the person that's giving the power of attorney, and are fit to make a decision. However, figures given by the Minister of State at the Department of Children, Equality, Disability, Integration and Youth has given figures, that's Anne Rabbitte, that Minister, that to date only 167 EPAs had been completed. And this is the nub of the matter. People using the system say they're having problems getting a solicitor to sign a legal practitioner's form, saying that the person looking to set up the EPA understands what it entails and what the potential consequences of doing so are, and that they are not under any duress or other pressure to do so. And this difficulty has arisen. The Law Society has issued us solicitors with a practice direction or a guidance note to its members expressing concerns that the DSS process does not allow solicitors sufficient insight to be able to sign with confidence the legal practitioner's statement, especially on the issue of whether the client is operating under duress. The Law Society has said that ultimately the Law Society believes that the implementation of the new system is limiting the ability of many people to express their preferences through the creation of an EPA, an enduring power of attorney. It says that the DSS's narrow and restrictive digital-first approach does not adequately take into account the digital proficiency of some elderly or vulnerable people, or those who are already likely to be disadvantaged. The DSS says that it does offer an alternative paper-based manual system for people uncomfortable with an online approach. In response to a series of detailed queries, the DSS has not to date been able to clarify how such a paper-based system operates and what documents are actually required. Both sides say that they recognise the importance of each other to the system and that they've engaged actively with each other. But the crux of the matter is this: a solicitor has serious obligations in terms of advising the donor of an EPA, an enduring power of attorney. And up to now, the solicitor has been involved from the very start, preparing all the documents necessary for an EPA. Now, however, ordinary people are using the DSS's service to use the online templates and so on to fill out documents, etc., to create their own EPA. The difficulty, however, is that they still need a solicitor to sign off on it, as it were, to sign off that the donor is not acting under duress, etc., etc. And solicitors have a difficulty with this because they see this not as a simple, straightforward rubber stamp sort of an operation, but one involving a significant amount of professional diligence and care. So from the point of view of the practice direction from the Law Society about enduring powers of attorney, a new practice direction was issued in February of 2024. And basically, the Law Society is saying that in order to fulfil all ethical and professional obligations in respect of the execution of enduring powers of attorney, solicitors must be vigilant in a wide range to a wide range of risk factors in the area, which includes undue influence, unconscionable conduct, conflict of interest and fraud. And practitioners, it says, this practice direction from the Law Society says that practitioners will be aware of the changes to enduring power of attorneys brought about by the commencement in 2023 of the Assisted Decision Making Capacity Act 2015. EPAs, enduring powers of attorney under the Act, require the provision of a legal statement to be provided by a legal practitioner pursuant to Section 60 of the Act. And it requires the legal practitioner, the solicitor, that after interviewing the donor and making necessary inquiries, he or she is satisfied that the donor understands the implications of creating the power, is satisfied that the donor is aware that he or she may vary or revoke the power prior to its registration and on or after its registration until the attorney notifies the director under Section 71A that the donor lacks capacity in relation to one or more of the relevant decisions which are the subject of the power of attorney, and this notification has been accepted by the director under Section 71C and has no reason to believe that the instrument is being executed by the donor as a result of fraud, coercion or undue pressure. Therefore, a practitioner, a solicitor, we've been told by the Law Society, must at a minimum, number one, interview the donor. Number two, make any necessary inquiries. Number three, be satisfied that the donor understands what they are doing in creating the EPA. Number four, be satisfied that the donor is aware that they may vary or revoke the power prior to registration. And number five, be satisfied that the practitioner has no reason to believe that the donor is not creating the EPA because of fraud, coercion or undue pressure. While there may be other modes by which a solicitor may place themselves in a position to be able to provide such a broad statement, practitioners should consider the possibilities in such respect on a case-by-case basis. But the solicitor, or the Law Society rather, is unequivocal that the clearest way to be able to do so is to be involved in the process from start to finish. And remember, this new process does not involve a solicitor being involved from start to finish, and that, quite frankly, is why the solicitor does not want to be involved or is reluctant to be involved, or why you may have encountered difficulty in getting a solicitor to be involved. There's no prohibition in the new legislation or in the DSS processes on the practitioner assisting clients in navigating the DSS portal for the creation of EPAs from the outset. It goes on then to say that solicitors should be wary of providing the legal statement where the client arrives to the solicitor's firm seeking just the legal statement with the remainder of the process conducted elsewhere. It may be more difficult to be satisfied that the practitioner has no reason to believe that there has been no fraud, coercion or undue pressure in circumstances where the solicitor has had no knowledge of what occurred when the process was commenced online elsewhere. That is the nub of the issue. We are being asked then as solicitors later on, late in the day, to sign off on the process, sign off this certificate when we are reluctant to do so because we have a significant professional obligation to ask the various questions that I've outlined there already. There has been various decisions in the courts, for example, in the High Court, in various cases, but it is reasonable to expect, the court has found, that the court will require a high professional standard and duty of care on the part of the solicitor. In particular, this SCR case, insofar as it considers the requirements incumbent upon a solicitor, would suggest that where a practitioner is unable to undertake a thorough engagement with a person wishing to create an EPA, they are unlikely to be able to provide the requisite legal statement. So that's the High Court telling us that. And then there are famous comments of Mr. Justice Barron in Doran versus Delaney, a 1996 case. He says in that case, 1996, that, quote, the solicitor is not a conduit pipe. Once he is acting professionally, he warrants that so far as his own acts are concerned, he has taken the care and applied skill and knowledge expected of a member of his profession. He cannot therefore accept his client's instructions without question when it is reasonable to query them. The DSS has also issued a code of practice for legal practitioners. The attention of practitioners is drawn to this document, in particular in the context of providing the legal statement at paragraph 2.6.3. The DSS statutory code of practice stipulates as follows: it is therefore important for you, the solicitor, to fully explain the scope, purpose and implications of an enduring power of attorney and ensure that the donor understands these. You should make and record full and detailed notes for reference should any query arise. These requirements are critically important, as the DSS may, as part of an investigation, for example in respect of the validity of an EPA or suitability of the attorney, request relevant records or information and or summons the legal practitioner as the witness. As such, the provision of the legal statement is not a simple or perfunctory statement or perfunctory exercise. Any practitioner who provides such a statement will have to engage fully with the client, taking a detailed attendance note in accordance with good professional practice and the requirements of the DSS's Code of Practice for Legal Practitioners. So the level of engagement required for solicitors to be in a position to provide the necessary statement as to capacity for the purposes of completion of an EPA creates a solicitor-client relationship. As such, solicitors will be required to observe all requirements for those relationships, which include obtaining anti-money laundering documentation, issuing terms and conditions of engagement, taking full and comprehensive instructions from the client, and providing advice in a manner setting which mitigates against the risk of undue influence, coercion or fraud by third parties. Where a donor is varying or revoking an EPA, Section 73 of the relevant Act requires a legal statement in similar terms, and the same considerations set out that I've discussed in this video apply in those circumstances. The Law Society is continuing to engage with relevant government departments and with the DSS in relation to this issue, but to summarise and conclude, the difficulty is that solicitors used to be involved in preparing the papers for an enduring power of attorney from the outset, and in doing so they could ask relevant questions from the donor, ensure that they were satisfied that the donor wasn't acting under duress or coercion or undue influence, and so on. However, the new situation allows people to make their own forms, create their own forms from the templates provided by the DSS online, but the difficulty then is they're coming in late in the process to a solicitor. The solicitor is asked to certify that the person, the donor, knows what they're doing, etc., etc., and that is a difficulty for solicitors because we are being brought in late in the day, and yet if things go wrong or if there's any question mark over the person's capacity or their understanding, etc., etc., solicitors are going to be on the hook and could be called as witnesses in any litigation, etc., etc. So that is the difficulty, and that is why the landscape has changed for anyone looking to create an enduring power of attorney. Hope you find this video useful.